Well, welcome everybody. My name is Carl Savoy. I'm the director of the Santa Fe College Innovative Product Development Center. And we are virtual right now, but usually we're at the GTech building in East Gainesville. And what we do is we work with startup companies and entrepreneurs to help them develop their products, develop a business plan, raise investment, and get their products to market. And our services are Price is Right, we're free. And we're here to help entrepreneurs wherever they are. They may have a napkin, an idea, they may have a business, they may want to expand a market. Wherever they are, we help them to get to the next level. And then we have 60 partners that we work with. And Hutchison Law Firm is one of our partners. And our partners provide services to our startup companies. We currently support about 55 startup companies, and our partners provide services at just in time. When they need that service, we refer them to our partner, and they get to work with them on have a great relationship. So we have 60 partners, we have 55 startups, and anyone, if you're interested or have an idea, you're welcome to reach out to myself or Elena, and we'd be glad to talk to you anytime. So with that, I'd like to thank Dan from Hutchison Law Firm. This is the 5th presentation that Dan has done. A couple were in person at GTech, some virtual ones. It's always great presentation. People always have at the end, they always have questions, and they always like the fact that it's a straightforward, easy to understand presentation. So Dan, you've always done a fantastic job. Welcome, and we're looking forward to the 10 legal mistakes entrepreneurs make. Welcome.
Thanks, Carl. And thanks for everybody who joined today. Just a brief thing about Hutchison. We are a boutique law firm. We focus on business transactions and helping companies get set up, funded, and ultimately exit. And so we have a very strong focus in the startup community and have been working in that space for almost 25 years now. So with that, I'm going to jump right into the presentation. This is a very high-level presentation to kind of identify certain areas where we see our clients making, some missteps as they get started, and just to plant some seeds into your mind as you start developing your own companies and moving forward, some things you might want to avoid. So, this is a quote we like to say: starting companies is like having babies, fun to conceive, but hell to deliver. It's great to have an idea, but really where the rubber hits the road is in the execution and moving forward with that idea into a tangible company that investors want to put their money into. So the first area that we see, and we listed this first for a reason, because it is very important that we see entrepreneurs kind of make missteps, is a failure to protect their intellectual property. Many times, all that you have is an idea. And IP, when we talk about intellectual property here, is not just things that you can patent or things that otherwise get formal protection, but it's the ideas, it's the ways that you run your business, it's how you interact with your team and your culture. And so what we encourage our clients to do is a few things. One, you as the founder or as an early participant in the company need to make sure that you're transferring the IP from your individual ownership to the company, so that your investors are investing in an entity that owns what they think they own. That can be done with a very simple agreement. If you have registered IP, it becomes a little bit more complex, but still not unduly burdensome. And so as you get started, it's important to have those agreements in place where the ideas that you've come up with actually get put into the company and therefore are owned by the company going forward. This creates barriers to entry for competitors of the business. It also ensures that if you have a multiple founder situation, if one were to leave, the company still has everything that it needs to move forward. We would encourage all of our clients to evaluate kind of what formal rights they have, whether that be patents, copyrights, or the growing field of trade secrets. If you're not familiar with what a trade secret is, think about the recipe for Coca-Cola. That is a typical trade secret. It is not patented because when you patent something, you have to make it public. So Coke protects that as a trade secret and takes steps to make sure that it doesn't get disclosed to people that it shouldn't be. To protect your intellectual property, you should be entering into non-disclosure agreements, IP assignment agreements like we talked about from the founders or employees into the company. And that should be applying to, all parties, not just founders or high-level employees. Low-level employees can see things and relay things. And if you have a facility or a factory, you should also get people to sign a very light NDA if they're coming to visit the facility, if they're going to see, things that you want to protect. The second kind of misstep that we see with our founders is, overwhelming angst and focus on dilution when they start taking in outside funds. I did a whole presentation on this a couple months ago. I think there's a video of it that Carl or Elena can give you access to. But really the question here and the way that we encourage people to think about dilution is, you can own 100% of a cupcake, or you can have your slice of a pie, or even like a very small slice of a wedding cake. So as the company grows in value, even if you have a smaller percentage of it, it's more likely to be worth more, despite the fact that you don't own the full 100%. What's important is to grow the value of the company and then compare your ownership percentage versus that value as it gets bigger. Don't constrain yourself by saying, well, this investor wants to give me $1 million, but they want 20 or 30% of my company. Eventually it's going to be worth $300 million. That's not a good deal for me. Well, really question whether you can get and quickly get, or as quickly get to that $300 million point without that $1 million of investment. The worst dilution that you can suffer is zero, and that's when your company closes because you're not willing to take on investors and suffer dilution at all. The third issue that we see a ton, and this is with startups and well-established companies, is a failure to read their contracts. And they just sign things and they don't know what's contained in them, and it leads to issues down the road. Not everyone has to read every contract, but someone in the company or your outside counsel should read all of the contracts. If you're a small company, we would encourage kind of 1 or 2 people to not only do kind of their substantive area, but all contracts overall, because they often interplay with each other. And then if you're using outside counsel, it's important to remember that we're not here to throw up impediments to your success. We want you to be successful just as much as you want to be successful. But what we can do is advise you as to the risks of what you're signing up for. We've seen a lot of things. We've seen how these develop over time, or where your company may go where you don't even see that currently. And so, when you're starting to do significant contracts or long-term contracts, or contracts that you can't get out of without a significant penalty, I would strongly advise you to use outside counsel to at least use as a sounding board and get advice as to the risk. just as everyone's kind of aware in the new digital environment, be very cautious of circulating editable documents. If you circulate drafts in Word, make sure that you're running comparisons or red lines when they come back. You might not identify all the changes that were made. And so just be aware of that. And then finally, when you're thinking about who in your company should be reviewing contracts, just remember that sales folks they're motivated a bit differently. They're often commission based. I have seen sales folks that will agree to terms that sell the company down the river for an additional, $2,000 on the top line. And so everybody has their role in a company. I don't know that a salesperson's role is to review contracts for institutional risk. I will leave it at that. The next kind of issue that we see is, when you're bringing people into the company, or you as the founder are starting the company, and you might have a different job or a full-time job that you're working, and you're doing this at the beginning as a side project. In our view, litigation is not a good business strategy. And so if you're having close calls with respect to intellectual property that you might have developed for your current employer, or you're looking to hire somebody away from a competitor, it's not a good strategy in our view for a startup company that is low on cash to kind of get into fights with larger companies around these items. So you should always keep copies of everything that you sign for your current employers, and all of your employees or associates should do that. They often contain invention assignment provisions where anything that you develop or create while you're an employee, sometimes just on company time, sometimes it's much more broad than that. And those things, like we talked about at the beginning, are then assigned to your employer and are no longer owned by you. So just tread cautiously here, beware of broadly defined terms. So like I said, it's one thing for your employer to have the right over things you develop while you're on company time using company equipment or facilities. It's another thing for them to own everything that you do in your spare time, in your garage, unaffiliated and unrelated to the company. So as you're signing those items, just be aware of how broad some employers try to make those. If you're in doubt, leave the idea behind with your company. Again, this goes to the litigation is not a good business strategy. If you're a coder and you've developed code for your employer and you want to take snippets of that code, recreate it separately outside of your employer. Do not take things with you that they arguably own. It's just going to cause issues down the road. And some people, well, a lot of our clients think, I'm a small startup company, my employer might be Cisco, for example, and Cisco's not going to come after me because I'm not worth anything. This is just an idea. Well, Cisco might not come after you today, but when you start hitting some real milestones and get a really valuable business, you all of a sudden become a much more attractive target for Cisco to come and assert ownership rights in. Not only that, this is something that investors are going to focus on significantly, making sure that you have clear title to what you say you own and no one else has a claim to it. Beware of lingering non-competes. If you're a high-ranking executive in a company, you're probably subject to a non-compete after you leave the business. Generally 1 to 2 years is enforceable, except in California, where they don't like any non-competes. But just be aware of what you're contractually bound to already, because you can structure around it. You can figure out ways to address this at the beginning that minimize issues down the road. And for some people, it might be waiting a year or 6 months or some period of time, but to provide that clarity, it can really be worth it. And then, as we mentioned before, all employees should sign proprietary information agreements, which deal with confidentiality of business materials, assignment of inventions, sometimes a non-solicit, sometimes a non-compete, depending on the level of the employee. The next mistake that we see is failure to account for founder stock vesting. This is also the subject of that earlier presentation that I gave, but when you just start your company and you're handing out stock to you and your co-founders, that should really serve as a reward to those individuals. You know, you've come up with the idea. Some of it serves to do what you've already done to date. A larger portion of it should really be geared towards keeping you committed to growing the idea and really executing on it. So the reason why we call it cheap stock is because when you start the company, your company has a value of 0. There's nothing in it. It has no ideas. It has no IP. So you can issue the stock at a very low per share price and then get the benefit of the appreciation in value as additional IP or things are created. By putting vesting on the founder stock, which we generally recommend, you know, a 4-year term for at least 75% of the stock, it ensures that your founders remain committed to the venture. And as you look down the road, as you start raising money, the people who are investing actual cash into the business are going to be very focused on the fact that you remain committed to the business. And so this is often a requirement for outside investors. And if it doesn't exist from the outset, they will put it in connection with the financing round. If someone were to leave because life happens, you know, it could be death, it could be a marriage, it could be a primary job relocation, or they might just lose interest, the company has the ability to take back a portion of that stock and then reallocate it to the replacement individual for that person without diluting everybody else. That is a key aspect where you start to think about, you know, if we agree there's 4 founders and everybody should have 25% of the company and one of you leave, that one probably shouldn't keep a quarter of the company and have everybody else be diluted as you bring in a new executive to replace them. Vesting can and should be subject to acceleration. What we're not attempting to do is, you know, ensure that you're going to stay through an exit event, through a sale of the business. What we're really trying to do is incentivize you to get the company to that exit event or sale of the business. And so if that occurs prior to, let's say, the 4-year period, you get to keep all of your stock. You are fully vested in it and it accelerates. It's not a penalty or a way to keep you past that large corporate event. I can't see everybody on the screen, but has anybody attempted to raise money for their company in the past? You can go off mute and chime in if you have. All right, I didn't hear anybody chime in, but if you haven't done it yet, let me tell you, it is, as the picture will indicate, an uphill climb. And many people underestimate how difficult it is to raise capital. This changes from year to year and how the market is going otherwise. I can tell you in 2008, it was virtually impossible to raise capital. During some of the boom times, it's been, you know, not easy, but not as difficult to raise capital. But it is something that pushes founders, one, outside of their comfort zone. You know, a lot of people aren't comfortable going and asking for money from strangers, or even asking for money from their friends and family. But if your company is going to survive and you have something that has a long development cycle, it's something that you're going to need to do. Our tips for this are, you know, keep the process as simple as possible. There are standard NVCA forms, which is the National Venture Capital Association form documents. If you're not using them or your counsel's not using them, we would encourage you to use them. These are broadly accepted documents that can limit, you know, the back and forth with investors. We generally encourage our clients not to, you know, engage in the most crazy terms that you've ever heard of. You know, keep it simple, a valuation, a per share price, standard kind of investor protections. And I will say again, when you're working with your counsel, a lot of times we get questions like, well, can I blank and insert whatever you want to do? And in short, the answer is generally yes, you can do that. We can document and paper pretty much anything that you want to come up with. But the more complicated it is, the less normal it is outside of what investors are used to seeing, the more likely they're going to say no. And you don't want to give anybody an excuse to say no for investing in your company. Focus on investors who bring value. This is really key. Not all money is worth the same thing. That may sound counterintuitive, but what we encourage clients to do is find money and investors who bring something more to the table than just the check. It could be industry connections, it could be expertise, it could be, you know, just having served on a board of a larger company and bringing that sort of credibility and credence to your board as a startup. It could be a knowledge leader in the industry. Whatever it is, you know, just taking the money will help you move a little bit forward and help you pay the bills, but bringing money with real value will help advance the company even further. In terms of setting expectations, we say at least 6 to 9 months of intensive effort by key management members. So your CEO, your CFO. If you're a small company, it's probably all of the founders. You know, taking meetings, negotiating documents, understanding, you know, you're going to get more no's than you get yeses. And so it's just very time intensive. And then finally, you want to enter the fundraising market with a strong set of numbers and a clear message. You should be working with who's ever putting together your financial statements to understand what they say, understand the message you want to convey from them. And these investors are not looking for, you know, a home run every time. What they want to hear is how you're getting from where you are to where you can make them a lot of money. And so you might have had 2 years of great growth and 1 year of declining growth. You should be able to explain why that happened. You should be able to understand where you're spending money and where you're going to spend their money going forward, and what milestones or other achievements can be made with the dollars that they're investing, because that's what they care about and that's what they can hold you accountable for. The goal should not be, you know, you invest $10 million in my company and we'll be the next Uber. Well, Uber has never made money. they run at a loss. And while some of their investors have made money, the company itself has never turned a profit. And so just saying you want to be the next X is probably not going to get you there with the investors. You need concrete. If you invest $10 million in my life sciences company, that will get us through phase 2, and we can submit to the FDA. And, with the next round of capital after that, here's how we feel like we can commercialize the product. Those sorts of understanding of your numbers and understanding the message that you want to deliver will really help you as you go out and attempt to raise capital. Another area where we see issues is the failure to properly document and incentivize employees and consultants. One of the siren songs of entrepreneurs is that we're not going to have any employees, we're just going to have all consultants. And that way we don't need to offer benefits, and we don't have to pay taxes or employment level taxes. That's all on them to handle themselves. Well, that's not always how the IRS views it. And, some people, even if identified as independent contractors or consultants, will be deemed by the IRS as employees. And so it's important to understand those rules and work with your counsel to make sure that you're operating in compliance with them. Unfortunately, they vary state by state. California has some of the most, I'll say, employee favorable, which means more people are deemed employees than consultants currently. And you may have seen in the news, some of the issues that's created in the gig economy for companies like Uber or Lyft, who, had previously asserted everyone was an independent contractor. In order to address this, it is important to have agreements with your employees and contractors. If you intend for someone to be a contractor, there's language that you can put into those agreements that identifies and sets forward the criteria for how you would actually qualify to do that. So a contractor should get some non-insignificant portion of its revenue from a company other than yours, or more than one company. A contractor should have the ability to control how it delivers deliverables to the company. You can have a time frame under which they do that, but you can't be micromanaging your consultants, or else they'll be more likely to be deemed employees. The other thing is where agreements become very important is if you're giving equity compensation. Don't make promises for 10,000 shares of your company, or 2% of your company, or 6%, or whatever it may be, and not have a document that supports and memorializes that, because those sorts of promises will come back to bite you in the future, especially if you become successful. There's a few options when you're doing equity compensation. One is restricted stock, one is options. They operate in very similar ways, but restricted stock, if you're granting it, has immediate tax impact to the recipient. They need to recognize as income the value of that stock. And then you can put vesting on it and restrictions that allow you to chip away at that if they don't perform. But that is the opposite of how options work, which is a right to buy stock in the future, but you don't currently have any rights as a stockholder. So as you think about this, a lot of companies start out granting stock because it's so cheap and you can start the holding period for long-term capital gains. But as value begins to appreciate in the business, that becomes harder and harder to continue to issue in the form of stock because of the tax implications. Also, if you're issuing stock, remember that they are then on your cap table, and they may have certain voting rights and other rights under statutory law, where holders of options frequently don't, because they are not actual equity stockholders at that point. Regardless of whether you're issuing stock or options, we would encourage you to create a stock incentive plan. And you can issue both under a plan like that. And one, it helps with securities law compliance. It also helps, memorialize how those stock awards or option awards are going to be treated. And finally, it allows them all to be treated in some ways in an overarching manner, instead of having individual documents that you have to go and amend or otherwise change as you go forward and circumstances adjust. We talked a little about employees versus independent contractors. Just to give you a bit of a war story on this, we had a very successful company. They were in the consulting space. They came to us and said, we have 4 employees and 86 independent contractors, and we're going to sell the business, and we want to do it in the next 2 months. Great, found a buyer, everything was lined up. Buyer's counsel came in and said, we don't think you have 86 independent contractors, we think you have 90 employees. And here's the host of issues, including your 401k plan is not in compliance, you owe all this back taxes or could owe these back taxes. And it delayed the deal 9 months and significantly adjusted expectations with respect to the value of the business. And eventually we did go through and person by person, converted people from independent contractors to employees formally with documentation, and also were required to have significant escrows put in place so that if the prior alleged violations of employees versus independent contractors came up and there was liability, the buyer was not on the hook for that, and the sellers would stand behind it. As I said, we took the client as they came to us. If we had gotten in there earlier, I think we could have avoided some of this. But this all goes to timing and when you do some of these things. There are definitely best practices, and we would encourage people to follow them as they go. We're also realists and understand that it's not always feasible for a startup company to either address everything, know about all of these issues, and even if they know about them, they might not have the funds or capacity to actually, put them in place. This one issue, though, is, as it says on the slide, 360 degrees of trouble. You can get into issues with your employees, you can get into issues with the IRS, your investors, co-founders. If you don't document your relationships with your employees, it just becomes a huge, huge mess. Which leads us into the next point, which is failure to keep good records. This is something that needs to be done on a continual basis. One example that some people think about is, the stereotypical person who puts all their receipts for the year in a box, and at the end of the year hands the box over to their accountant and expects them to be able to do their tax return. That doesn't work. You should be keeping copies of contracts. You should be keeping copies of all your investment documents. Everything where you're agreeing to do something, you should have a copy and you should keep it in digital form. With the advent of, moving forward with computers and digital storage, whereas I started practicing in 2006, so this has always been kind of the norm for me. But, some of my partners who go back 20 or 30 years, there was a little more leeway of not having every document through the company's life cycle because so many things were kept in paper records and there was limited space. That leeway has gone by the wayside. There is an expectation for acquirers, for investors, that you will have all of these records and that they will be organized. It's often used as a test by your investors when they send over a diligence checklist to see how organized you actually are as a company. And it can be, a very bad first impression if you've passed the first hurdle. They're looking at you more seriously. They've gotten counsel involved. They want to write the check, but you can't produce the records that support, what your business has been doing, what your key contracts are. Pages are missing from them, signatures are missing from some counterparties. It's just not a great situation and doesn't make you or the company look good. That's not to say that this can't be cleaned up after the fact, but it really is a massive undertaking, far more than you would expect, and it will delay your plans for closing investment rounds or closing significant corporate transactions like sales or IPOs. It also just leads to unnecessary disputes with counterparties. If you don't have a clear record of what was agreed to, it raises doubts and it opens you up to liability that really just shouldn't exist. So keep that in mind. I've given this presentation a couple times, a few times with my partner, Fred, whose name is Hutchison. He's the name on the door. And his motto with respect to record keeping is, you can pay us now or you can pay us more later. But at some point you need to pay the piper on this record keeping and make sure that it's organized. And it's really short. It might seem like a lot of cost and time up front, but it's going to be a significant savings over trying to rectify it in the future. An anecdote that Fred liked to tell when we gave this presentation was he had a client for many years. We would send him documents. He would acknowledge receipt, say, I signed it, put it in the file. Never sent them back to us to keep in our records. And we got to the point of doing a sale of the business, and Fred went over in person because this was the 90s and that's what you did. And the guy pulled open a file drawer, and there was every document that Fred had ever sent to him, stacked in reverse chronological order. The last one would just go on top, no organization, nothing else. And it was just probably 2,000 loose pages of documentation, some signed, some not, in just a single stack. That's not the worst that we've seen, but that is also not best practice. So, keep things organized, keep copies in digital form. God forbid something had happened at their office, like a fire or a flood, there would have been no record of any of that. This is a related topic, but it's something that differs a little bit more. And one that required its own bullet point. And it's really important for you to keep track of inaccurate records of money coming in and money going out. The reason for that is, as we talked about, when you go to raise money, this is what the story of the business is going to be based on. How much money have you taken in? It can't be, well, I got $1,500 from my uncle and, $200 from this person and a little bit more from this other individual who I don't really remember. And none of them expect to be, paid back. It was all just friends and family. Well, again, if you become successful, your friends and your family may have a different recollection of what they were actually doing with that $200 or $1,500 that they quote unquote loaned you and never expected to be repaid. So you know, we advise against bar napkins and handshakes. A bar napkin is better than a handshake, but you know, document it, document what the expectation was at the time that the money came into the business, and keep that in the files. The other thing we hear a lot is we'll meet with an accountant before we need to file taxes. And you know, there's this misconception that you don't need to file taxes if you're just losing money. Well, that's not always the case, and you should meet with an accountant early on, because there are ways that you can structure certain actions and tax credits and other things that you could be using to actually make your money go further. And so even if you're recording a loss or otherwise not profitable, there are tax attributes that that a good accountant can help you identify. And all of this goes into not just the story that you're telling investors, but also the story that you're telling yourself. And you know, how successful is your business? How worthwhile is this as a venture for yourself? If you're spending 80 hours a week to lose $20,000 or $30,000 a year, that's you at least need to know that, so that you can make a conscious decision of, you know, is the juice worth the squeeze here? And especially when you start interacting with customers, you need to make sure that you're setting the price for your product at an appropriate level to cover your costs and give you some profit. Or if you're doing it as a loss leader, again, you're going and consciously making that decision. This is a hard one, and this is why we kept it towards the end of the presentation. But one of the hardest things for founders to reconcile with and deal with is a failure to listen and delegate. We encounter our practice is focused on tech and life science companies. And so on both sides of that business, we encounter really smart people who are experts in their field and, you know, are well regarded and deservedly so in their field of expertise. If you're a research scientist and you've developed a great new molecule, one of your strengths may not be managing employees. It may not be formulating Excel spreadsheets to do financial statements. And so really understanding where your core competencies and strengths lie and where you need a little bit of help will help your business move forward and become the best business that it can be. We encourage people to assemble a good team of advisors. There are formal directors under corporate law that can help serve in this capacity. You can also consider advisory boards, which are lower commitment, lower risk, but people in your industry that can provide you with mentorship and be a sounding board. You might call them once or twice a year. You might call them once or twice a day. It depends, but you know, having those resources and perhaps compensating them with, you know, 0.5% of stock or 0.25%, depending on their commitment, is money well spent. And then, you know, not to toot our own horn, but having good service providers, having good counsel that works in your space, having an accountant that knows how to work with startup companies and can help advise us to tax credits and other things. Those are all key to the success of your business. And what I would say is we're a boutique law firm, and we're very aware of kind of the niche and space that we play in. And for service providers, as well as directors and advisory members, the person that gets you from A to B may not be the right person to get you from B to C or from C to D. And, you know, we're all professionals. We all are self-aware enough to know that, you know, a startup attorney in many instances is great to help you start your business and run it through, but they're probably not the ones to lead you with an IPO. You just need a larger law firm with more resources and better SEC connections to do that. Same with accountants, same with, advisory members. The second part of this is you build a great team. Now you need to be prepared to delegate to that team. If you're not great at spreadsheets, don't interject yourself in creating the spreadsheets, but be there to review and understand and ask questions. If you're not great at managing HR, bring in a strong HR director. Know what you're good at, know what you bring value with, and then delegate those either non-essential functions or essential functions outside of your area of expertise. It's just not worth your time to become an expert on tax law when you can hire a good accountant. As we said before, at its core, just keep it simple. Your technology could be really complex. Your business strategy could be really complex. But when it comes to documentation, to management, to issuing equity, just keep it simple. Go with what has worked for other companies, and trust your advisors to be a partner with you to help you advance as the company grows. You don't want investors to have an excuse to say no because something looks outside the ordinary, or they can't understand or appreciate the risk or lack of risk associated with a really inventive new corporate structure or employment plan, things like that. So I'm going to open it up for questions. I know that was a lot of information to get through in 40 minutes or 50 minutes. So the floor is open for any questions.
Yeah, I have a question. Document management. Do you have recommended service or products for doing that? I mean, I know there's things like DocuSign, although I haven't deep dived into that. Like that, or other products.
So I think most of our clients use either Dropbox or Google Drive at the initial stage, and they just keep it kind of well organized. The key point is use a system that you're going to actually use that makes it easy for you to have access to your documents. We as a law firm use a product called iManage, which I would not advise for an entrepreneurial startup company, but we have thousands of clients that we need to organize all of their files for. So that's kind of beyond what you would need. I am a big fan of DocuSign. One, because you load it in, you tell it who you need signatures from, and it can send the reminders, and it will keep a record of those documents. I wouldn't use that as your only document retention. I would use Google Drive or Box or Dropbox, but it's really whatever you find easiest to use. If you have a larger team, we use Microsoft Office as our main sort of document word processing software. They have they have OneDrive through that to share files. It's really just have one organized repository of what I would say is kind of company records. And then as you're doing drafts of things, you might store those locally, you might store them otherwise, but have a company record kind of organized file system. And with respect to cap tables and equity issuances, a lot of clients are using Carta now as a software product to help manage those issuances, and that has been embraced by the investment community as well. So, other questions?
So I got a question for you. In regards to COVID and what's happening in COVID, have you seen any changes with startups or with the way that you guys are working, or anything in regards to the new virtual environment that we've all been part of?
Yeah, so I will say that COVID initially caused a significant slowdown in our business, just as companies themselves were adjusting in kind of finding their footing. And I will say money froze for a not insignificant amount of time, probably a quarter or a little bit over a quarter. But money is flowing again. And I think a lot of investment funds are looking at this as an opportunity to get some deals and get some deals done. One thing we've seen that's been slowing it down is the PPP loans that were, issued by the Treasury, issued fairly quickly, not being forgiven quite as quickly, which is causing some issues with investment funds that don't want to acquire companies that have PPP loans until they're forgiven. But day to day, I've probably seen an uptick in entrepreneurial activity, whether that's a function of people having lost their jobs or working from home and realizing that they have more time, or they're just trapped in their house because of quarantine rules, that they have time to devote to these side projects that have kind of been lingering there for a little while. But overall, I think it hasn't impacted it substantially beyond, as I was joking before, I have a lot more video conferences that used to be conference calls that, take up a lot more of my day now than anything else. We, although I'm based in Raleigh, North Carolina, we obviously cover a large swath of Florida, much of the Southeast, and kind of throughout the country. So, we don't actually meet with our clients in person all that much, even before COVID. And so that really hasn't been an issue. But, all of the conferences getting rescheduled or canceled, moving virtual, I would say there's less of the networking opportunities for entrepreneurs to kind of meet investors in a informal way before they go and make the ask for the cash than there used to be. But that'll come back, or we'll adjust even more.
It's good. Any other questions? All right, well, Dan, thanks so much again for a great presentation. Very informative. We will put out a survey. Elena will put out a survey after this presentation. She'll include your contact info and anything else that you would like to include, the presentation or anything else, Dan, she can include that in the email as well. We all thank you so much for coming, and next week we'll have another webinar. And we just hope you have a great week, everybody.